就说你如果在美国黑了20几年、30几年，到今天都没有身份，那你是否符合哪些特殊的法律可以使你能拿到绿卡？大家好，我是秦苏珊律师。那今天的话呢，我跟我们的律师团队就是Judge Hum 就是洪法官，还有我们的 Craig 律师讨论一下，就是 245I 就是245I。最近呢，有很多人他过来咨询，就说我来美国30年了，20几年了，那这些案子是很老，很多人他在20年以前、30年以前他都是偷渡过来的，或者是拿假护照过来的。那这么多年过去的话呢，当然他们都成家了、立业了，可是身份一直没有解决那孩子的话呢，都是美国出生的，都已经是美国公民，超过21岁、30多岁了，可以帮父母申请绿卡了。那父母在这边呢，也都很多已经很成功的人士了，或者说工作在美国交税很多年了，可是身份迟迟拿不到。所以今天的话呢，我就会请我们的洪法官，他在纽约做了30年的移民法官，来讲解一下，就说你如果在美国黑了20几年、30几年，到今天都没有身份，那你是否符合哪些特殊的法律可以使你能拿到绿卡？ Hey, Judge Hum, good morning.
Hi, good morning to you.
So lately, we've had a lot of questions from immigrants that have been in the United States, especially in New York or Los Angeles, for more than 30 years. So these people are mainly from Fujian province. Back in the days, when they came to the United States, they had fake passports or fake names, and then at the airport or at the port of the entry, they came in. They didn't have any status. So 30 years later, they have established a business, they have US citizen children or parents or spouse, but they don't have a green card. And a lot of them don't know if they actually fit into any exceptions or does any special law apply to them. So lately, we've encountered some of the consultations and then people say, do I qualify for 245I? So can you tell us what's 245I and who is eligible for those?
245I, as the provision suggests, talks about adjustment of status, Section 245 in the Immigration Nationality Act. But 245I is a subsection that was added in the last major change in the Immigration Nationality Act. This provided a means for people to adjust their status while here in the United States, notwithstanding how they entered. In other words, even if they came in without inspection, would they be entitled to adjust their status if they were otherwise eligible for it? Now, Congress, this was a congressional change, and this was a means, 245I, to address the particular problem of many individuals coming into the United States and seeking adjustment of status later on in their immigration history. And I say later on because 245I requires an individual to show that they have made a visa petition application, either for family or for employment-based. Now, if you can show that you have made a visa application, not that it had been approved, not that it was decided on the merits of the case, but even if it was an application that was found to be insufficient under 245I, that was sufficient to show that the individual would be entitled to seek adjustment of status here in the United States. The caveat to this is under 245I, no matter whether the petition was approved or not, as long as you can demonstrate you filed a visa petition, either based upon marriage or based upon relationship or based upon employment based, as long as you can demonstrate you made an application within the time period that's permitted under the Act, you're entitled to adjustment of status. And the caveat here, is that you had to pay the penalty, a fee, an extra fee. I think the amount was $1,000 at the time, which in the late 70s and early 80s tended to be a significant amount. But as long as you paid the penalty, as long as you can show that you made an application for a visa sometime in the past, you were entitled to seek adjustment of status under 245I.
Judge Hum, you just said something that's so important because for the last 10 years, a lot of the people entered EWI, enter without inspection, they just know, I need to do 601 waiver, I need to, get out of the country and do consular processing. So a lot of people, after they entered the United States for more than 10 years, they're afraid of going back to China. So they deferred on their status. So now what you just mentioned is something that's really interesting. So I'm going to explain that in Chinese so that way our audience can understand. Yeah. 那刚才洪法官讲了一个非常有用的东西，他就说，那245I 这条法案的话呢，也就是说，你当年就算你是偷渡入境美国的， 但是 I45I 这一条法案，它就是保护这些人，就比方说你是在哪一个年份之前入境的话呢，你就可以设这条法案的保护。那只要你是在就是这之前你有提交，就是家属移民，比方说有130或者是140，法庭就是法律，它不要求说你的130一定要批准，或者是说你的140一定要批准，它只要你这边能有就是当时有提交的130、140，那么你就可以不需要出境美国，在美国境内去调整身份，就算你曾经是偷渡过来的。所以呢，这条信息是非常重要。Thank you, Judge Ham. So I basically just interpreted what you just said in Chinese because that's something a lot of our EWI clients, their concerns because they don't want to leave the United States to go back to China or any other countries to go through the MVC processing, and because they worry they might not be able to come back to reunite with their families. Okay, so the 245I. So what's the cutoff time, like timeline? When do they have to enter in order to get protection under this law?
Well, they have to have entered the United States after the change in the Immigration Act that brought about 245I. And I don't recall the exact date, but that's when the Congress, in passing this particular provision to add to the Immigration Nationality Act, recognized that going back to someone's home country to get a visa is an onerous proposition because they have to relocate, go to the embassy or a consulate, apply, go through the process, get their medical, and then get the visa to come back to the United States. And as you say, they may not, because there's no consular reviewability through the federal courts, whatever their decision is, it becomes final. So there is a hesitancy on the part of people trying to get their permanent residence and having to go back to their home country. And at that time, the one family policy was being enforced strictly. So those individuals that had more than one child or were contemplating to have more than one child, in China particularly, they were afraid that they would be subject to persecution upon their return. So 245I said, if you pay the penalty and you can demonstrate you filed a visa application at any time, it doesn't have to be approved. It doesn't have to be supported by evidence. As long as you filed, you would be entitled to 245I and adjustment of status here in the United States. The penalty was to offset the requirement that you had to go back to your home country to get a visa. This was the government's way of saying, okay, if you wish to get a permanent resident card here in the United States and you otherwise qualify, you pay the penalty, you don't have to go back to your home country.
All right. Yeah. So last week I had a consultation and the client was concerned because she was married, 20 years ago. So I guess her ex-spouse filed the I-130 and the I-130 was not approved. So she was divorced and then subsequently she married somebody else. So now with the new spouse, so she wanted to know, she did file this I-130, but it was petitioned by the ex-spouse, 20 some years ago. I think it was prior to 2001. So she wanted to know, she's like, do I still qualify under 245I? The act was enacted, I think it was in 1998 or 1999. I have to do some research on that.
I believe it was 96, the implementation. The act was proposed, I think, in 96. It came into effect in 97. So.
Right. So she said she's divorced, and it was petitioned by ex-spouse. So, so you mentioned it, as long as you file the petition, whether it's labor certification I-140 or family petition I-130, you just need to prove that such action was taken.
Well, not even that action had been taken. All you have to demonstrate is that you filed the petition. So there's a receipt. If there's a receipt stamp on the application or acknowledgement that it was received by the agency, that is sufficient for 245I eligibility.
That's good news for a lot of our older immigrants because especially in New York, we have a lot of Fujian, immigrants. They've been here for more than 30 years. And I think that's good news because a lot of, attorneys or people work in this immigration field don't know because this is such an old section of the law. Okay, so I'm just going to explain that to our audience. 那刚才洪法官讲的就是说这个245I，就是你只要能证明，也就是说在2000年，2000 2001年之前呢，就是你有提交130或者是140都不需要批准，你只要能拿出就是 receipt， 也就是说130或140的证据证明当初有向移民局去提交，有拿到这个收据。那在这种情况的话呢，就算你是偷渡过来的，你也可以在美国境内去调整绿卡，你不需要出境美国。因为很多人偷渡过来都认为我必须要出境，我不想出境，我怎么办？那我要不要跟公民结婚还是怎么样？所以如果说你的案子呢是就是很老的案子，来了美国很多年了，你不确定，就是你偷渡过来的，你不确定你现在有美国公民子女，或者说父母或者配偶，你能不能就是可以不用出境，在美国境内去调整这个身份
Well, here's the caveat though also. Whoever is contemplating and they feel that they're within this eligibility range, they should consult with an immigration professional just to make sure. There may be other factors that have to be looked at for 245I eligibility because there are the requirements of 245. In addition to the other eligibility things that we talked about. So, conviction of a criminal record, the ability to, public charge issues, these all go into the consideration of whether the person is 245 eligible to get a permanent resident card. So, I suggest anybody who thinks that they are eligible, talk to a legal professional, particularly in the field of immigration, to find out if they are actually eligible for the consideration of 245I.